100.9 WXIR. This is Evidence of Design, and I'm your host, Jason Taylor. Good morning, everyone, and welcome to Evidence of Design. I'm your host, Jason Taylor, and I'm joined today by my co-host, Matt Treadwell.
Good morning, Jason.
As its name implies, this show is all about finding the evidence that points to how our modern political economy is designed. Matt and I have tried to make the case that neoliberalism, or the political and economic practices of deregulating the private sector, shrinking the federal government's involvement in social welfare, and the proliferation of big business, all of that is the design of modern America. On today's episode, we'll investigate two pieces of evidence: a recent Supreme Court decision that bars workers from collectively suing employers, and the Trump administration's proposed changes to the Health and Human Services Department. But I want to remind everyone listening out there today in Rochester or wherever you are that you can participate in our discussion. Please do email us at any time at evidenceofdesign101@gmail.com or give us a call at 585-219-8889. I should also say, but of course if you're listening to us right now, that you probably know that you can tune into us on the radio at 100.9 FM WXIR or online at 1009WXIR.com. Matt, let's just jump right into it and take it away.
Sensations make me feel the pleasures of a normal man. These sensations spare the insults, leave them for another day. I've got the spirit, lose the feeling, take the shelf away.
Matt, who painted that song right there?
That was the artist Joy Division with the song Disorder from their 1979 seminal classic, Unknown Pleasures.
I was going to say, I actually knew that one there. Joy Division, I think a band from the 80s?
Late 70s into the 80s. Later became New Order after the tragic death of their frontman, Ian Curtis.
That's right. Yeah, that New Order is still around?
In a manner of speaking. They've kind of splintered a bit. One of the original members, Peter Hook, is kind of like not on speaking terms with the band anymore. It's a complicated situation.
I can imagine.
Yeah.
Well, thank you for leading us off. And as mentioned, folks, we are going to talk about two real-life examples today of what we think is sort of promoting the wrongness in American society because of this thing that we've kept talking about called neoliberalism. I was talking to some folks in my life this week, and they were telling me, like, you know, Jason, you're always talking about this neoliberalism thing, but you never really give real-life examples. I kind of disagree. I hope that we have been giving real-life examples throughout the past 14 weeks of the show, talking about varied things such as gun policy and taxation, and also just really just the worshiping of big business in America. So that conversation, though, really inspired me to say, okay, look, let's not use big fancy terms like neoliberalism, perhaps, and let's use real-life examples that have been happening in the past 2 to 3 weeks to really examine this thing that we're talking about, which is the erosion of social solidarity in favor of big business in America. So let's take it away. The first thing we're talking about is a Supreme Court decision that happened about 2 weeks ago. Let's hear the introduction to that case.
Mr. Clement, do you recognize that this kind of contract
And let's try
argument is
different.
term
Yes.
in case 16-285, Epic Systems Corporation versus Lewis, and the consolidated cases. Mr. Clement.
All right. So that was that was actually last October 2017 when the Supreme Court was hearing the case Lewis versus Epic Systems Corporation. So Epic Systems Corporation is a privately held healthcare software corporation. In April of 2014, the Epic Systems Administration sent an email to some of its employees. The email contained a modified arbitration agreement that required employees to settle wage and hour pay disputes through what's known as individual arbitration. For those that don't know, arbitration is the process of settling disputes outside of the court system. In other words, Epic was requiring its employees to waive their right to collectively sue the company over wage and hour disputes in the court system. Instead, the employees were being required to settle pay differences individually and with the company itself. So that email that contained the modified arbitration agreement that Epic Systems sent to its employees, it stated that continued employment with the company constituted acceptance of the agreement. In other words, Matt, if employees did not agree, they would simply quit. There was no option to decline or reject the modified arbitration agreement in the email. Employees could only consent. So shortly after this all happened, the email was sent out in 2014 by the Epic Systems Administration. Jacob Lewis, who was an employee at Epic, filed a class action lawsuit against Epic Systems, and Lewis alleged that the company failed to compensate him and other employees for overtime pay. Lewis filed the lawsuit in the Federal District Court of Western Wisconsin and claimed that Epic's mandatory arbitration agreement violated what's known as Section 7 of the National Labor Relations Act. And we'll get into that act and explain it in detail. But Epic countered that filing, and they tried to dismiss the lawsuit and compel Lewis to, well, as their agreement said, to individually arbitrate the dispute. However, the district court judge ended up siding with Lewis that Epic's arbitration agreement was unlawful. But the story doesn't end there. Epic Systems was, of course, unsatisfied with the verdict, and they appealed the case to a higher court, the U.S. 7th Circuit of Appeals. So that case went in front of a panel of 3 judges, and even though it was heard again, Lewis was once again deemed victorious in court. The judges found that Epic Systems' arbitration agreement violated Section 7 of the National Labor Relations Act. Epic countered unsuccessfully again that what's known as the Federal Arbitration Act, which we'll also get into, demanded that its arbitration agreement be enforced. So despite 2 unfavorable verdicts, Epic filed a writ of certiorari. That is the best word ever, a writ of certiorari, and it's just basically a process by which a higher court reviews the decisions of a lower court. So Epic filed that, essentially appealing it again to the highest court, and there's only one higher court you can go to. That's the U.S. Supreme Court, which agreed to hear Epic's case. So the U.S. Supreme Court heard the arguments last October, and they just reached a verdict on May 21st, just a few weeks ago. Their verdict, in a 5-4 decision, reversed the rulings of the lower courts and held that Epic Systems' arbitration agreement must be enforced, as according to the Federal Arbitration Act. The court's decision was split among party lines, with the more conservative justices Gorsuch, Roberts, Alito, Kennedy, and Thomas forming the majority, and the more liberal justices Ginsburg, Breyer, Sotomayor, and Kagan forming the minority. So all of this really brings up one question that the courts heard, and it's this. Can an employer prohibit employees from pursuing work-related claims through a class action lawsuit? According to the Supreme Court, the answer is yes. An employer can prohibit employees from collectively suing a company on behalf of not allegedly paying them their due wages.
I was shocked when I first heard about this. The Supreme Court's decision.
In what way?
I just felt like such a betrayal, almost, in a sense. This is taking away power from workers to basically, unionize on some level and have some level of power to fight for their rights and for their well-being as employees.
Yeah, there is a difference here between workers unionizing and workers taking a collective or a class action lawsuit. So at least how this case played out, it wasn't talking about unionizing, and in fact, it's worth noting, Matt, that this case only applies to non-union private sector employees, to my knowledge, in my reading of the case. So only applies to employees who are non-unionized and in the private sector, I believe. Let's hear, though, you mentioned it's like a reversal and you're shocked about it. Let's hear Justice Stephen Breyer talking about how this court decision, he thinks, reverses almost a century of really labor laws in the United States. Let's take a listen.
I'm worried about what you're saying is overturning labor law that goes back to, for FDR, at least, the entire heart of the New Deal. What we have here is a statute, two of them, Norris LaGuardia, the NLRA, which for years have been interpreted the way Justice Kagan said. They say that they protect the joining together. Those are the words, joining together, those are the words of our interpretation of you could have two workers to seek to improve working conditions through resort to administrative and judicial forums. Okay? That's the argument against you. I want to be sure that I didn't see, Concepcion. I've read it too. We all have. But I haven't seen a way that you can, in fact, win the case, which you certainly want to do, without undermining and changing radically what has gone back to the New Deal. That is the interpretation of Norris LaGuardia and the NLRA.
So again, that was Justice Stephen Breyer of the Supreme Court talking to the lawyer, Robert Clement, who was representing the employers in this case, Lewis versus Epic Systems Corporation.
The heart.
The heart. Yeah, Breyer talks, he has interesting diction. I don't know, it's very interesting to hear him talk, but he's arguing, his thing is like, look, ever since the New Deal, we have really said workers can band together to seek redress against harmful practices by companies. So if companies are ripping off workers, like not paying them what they're allowed to pay, or what they should be paid, workers should be able, and have been able, to band together and fight those companies in some fashion. And he referenced a piece of legislation there that we've also referenced called the National Labor Relations Act. So to be really brief, folks, this was at the center of the case, and it's really important. The National Labor Relations Act was passed in 1935, and Section 7 of the NLRA says this: employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in, and here's the major point, to engage in other concerted activities for the purpose of collective bargaining or mutual aid or protection. So if I read that again and you looked at the legal language, which is always kind of complicated, it doesn't mention collective action. What Section 7 of the NLRA does mention is essentially unionizing, to self-organization, to form, join, or assist labor organizations. It does not expressly mention class action lawsuits, which is what Jacob Lewis filed on behalf of his employees in this case. So,
yet I'm seeing, at the point you emphasized, other concerted activities that wouldn't be considered joining together.
Well, that was the heart of the case, Matt. So Neil Gorsuch, who formed he wrote the majority opinion for the court. Neil Gorsuch wrote that Section 7 does not confer a right to class or collective action. And he says that, back when the NLRA was adopted, there was no such thing as class action. Class action didn't really emerge until 1966. And so his argument is basically, look, if it does not say class action, the law does not apply to it. And that's because we know Gorsuch and other conservative justices are oftentimes what's the word?
Originalists.
Originalists, right. So they interpret the Constitution verbatim, typically. And so the counter-argument from the minority was written by Ruth Bader Ginsburg, and she has this term that I'd never heard of before. It's called the, if I can even pronounce it, adjustum generis. And that is basically, it's Latin for saying that statutes in law should have a sort of meaning beyond their original scope. So, for example, although the NLRA does not expressly mention class action, it should be interpreted as protecting a broader scope, just because we can't in law expressly write out every single thing that laws are meant to include or exclude, because it would just be simply impossible. It would be too complicated. And so she argues, look, it's quite obvious that the NLRA, the National Labor Relations Act, was meant to protect workers' rights to have class actions. So that is kind of the argument. So there's one side of it. So here's the National Labor Relations Act that protects workers' rights to unionize, but whether or not, or depending on your opinion, does or does not protect workers' rights to file class action lawsuits.
Collectively.
There's this other act, though, that we mentioned called the Federal Arbitration Act. This was passed in 1925, 10 years before the Labor Relations Act. And Matt, do you want to read us what this Arbitration Act is? It is quite wordy, and I think you might be able to communicate it quite well.
Sure. I don't know if I can do that voice, Jason.
Let's hear the noble landed gentry and the wealthy British elite.
A written provision in any maritime transaction or a contract evidencing a transaction involving commerce to settle by arbitration the controversy thereafter arising out of such contract or transaction, nor the refusal to perform the law or any part thereof or any agreement in writing to submit to arbitration existing controversy.
Right, so it goes on. The you can read that quite well in the landed gentry voice. The point is the Federal Arbitration Act is meant to protect the ability to arbitrate. It was passed back in 1925, but there's this last point to the Arbitration Act. It's what's called the Savings Clause, and it says, basically, look, arbitration acts are irrevocable, they must be enforced, and they're valid, unless there is another law that would prohibit them from going into effect. So the argument from Lewis and the minority justices on the court was that the NLRA would revoke the Federal Arbitration Act's arbitration in this case. So all this complicated stuff is basically saying, look, workers have the right to collectively sue their companies. And the Arbitration Act should not have gone forward because the NLRA would protect their right to collectively sue. The Supreme Court decided ultimately no, workers do not have the right to collectively sue if they waive their rights under an arbitration agreement. So that's all the fancy technical stuff behind the scenes. Let's talk about what that really means. So if you go get a job and you're a private sector employee, when you're hired, or a condition upon your hiring, your employer could hand you something and, like long legal documents or wording or whatever, and it would basically say, I hereby agree to not pursue collective class action against X company in court. And then that would be a term of condition upon your employment. So you are waiving your right to go to court to seek redress if the company does not pay you wages. And that can be what's happening, and that is what's happening. According to a post by according to research by the Economic Policy Institute, which is worth pointing out, they are typically left-leaning, but I guess they're left-leaning in the sense that they support the rights of laborers. I'm not sure if that's really something that should be debated, but a 2017 report by the Economic Policy Institute says that in 1992, only 2% of employers, of private sector non-union employers, I should say, used mandatory arbitration agreements. In 2017, so just last year, it was 54%. So in the past 30 years, we went from 2% of non-union private sector employers having mandatory arbitration agreements to nowadays 54% of non-union private sector employers using mandatory arbitration agreements.
More than half.
Yep, absolutely. So more than half of all non-union private sector employers in this country, according to this report that came out last year by the Economic Policy Institute, use these mandatory arbitration agreements that were just supported and essentially made unequivocally lawful by the Supreme Court. If you do the math in terms of how many people in America work in non-union private sector jobs, that means 60 million Americans in the U.S. no longer have the right to collectively sue on behalf of pay and wage and hour disputes.
Not an insignificant amount of people.
That's right. That's about 1/3 of all the workers in the U.S. So the whole point of going through this is that when people talk about like neoliberalism, they're like, what is neoliberalism? What does that mean? Like, it's this long-term trend, this long-term belief, this long-term implementation of practices in the U.S. that have slowly eroded the rights of workers in favor of corporations. And I think that this Supreme Court decision that came out 3 weeks ago is a perfect example of it. You may have not heard about this, and you may be like, Jason, you are the most boring person in the world talking about all this stuff. And it kind of is boring, but that's the whole point. Because the whole point is that it's boring and no one has time or the patience to look at it, and then your rights are slowly eroded until you got nothing left. And so the whole point is we have to have these discussions about these things because no one else is going to talk about it because the people who are in power sure ain't going to be doing that. So that's kind of the whole point about Lewis versus Epic Systems Corporation. I do want to bring up one last piece that Neil Gorsuch, the conservative justice who was appointed by Donald Trump, and also who wouldn't have been appointed if we all remember in 2015, 2016, when a vacancy was created in the Supreme Court because conservative Justice Antonin Scalia died. Barack Obama nominated Merrick Garland, but the Senate Majority Leader Mitch McConnell said that the Senate would not hear, under any circumstances, a hearing to appoint a Supreme Court judge under the rest of Obama's term because, as he put it, the American people should be the ones to decide. And he was making that argument saying that because it's a presidential election year coming up, we should wait for the next president to make the decision because, in theory, that's the American people deciding, even though the American people decided Barack Obama to be president for 4 years. But
yeah, well, you know.
Yeah. So, we wouldn't ever have Gorsuch if, the Senate actually did its constitutional job. If you're a constitutional originalist, as
Gorsuch claims to be.
Gorsuch claims to be. I would hope that he would be like, yeah, the Senate probably should have held a hearing on the Supreme Court as it says in the Constitution.
And I should abdicate my position right now.
So,
Merrick Garland, come on board.
Yeah, just putting that out there. So Gorsuch ends his majority opinion, and he says something really interesting to me. He says, so allowing judges, and he's speaking about the Supreme Court here, allowing Supreme Court justices to pick and choose between statutes such as the NLRA and the Federal Arbitration Act risks transforming them from expounders of what the law is into policymakers choosing what the law should be. Our rules, aiming for harmony over conflict in statutory interpretation, grow from an appreciation that it's the job of Congress, by legislation, both to write laws and to repeal them. He goes on to say, and I'm roughly paraphrasing this, the court is not free to substitute its preferred economic policies for those chosen by the people's representatives. So what Gorsuch is saying there is, look, it's not up to the Supreme Court to decide what the law should be. We're just here to interpret the law. And I completely agree with him. Like, that is the job of the Supreme Court, nominally, right? The Supreme Court is meant to interpret the legality of laws in the United States as consonant with the U.S. Constitution. However, he goes on to say that the court is not free to substitute its preferred economic policies for those chosen by the people's representatives. What he's saying is, if you have a problem with the law, go to Congress and make them do it. And I completely understand that, but he knows that nothing's going to change because he's part of that group of people who just want to continually erode the rights of laborers in favor of corporations. And so he's pushing all of this sort of moral and contextual arguments and just saying the law is the law. The Federal Arbitration Act says that workers have to abide by arbitrations they sign. So here it is.
Nothing I can do about it.
Nothing I can do about it. And again, I don't necessarily disagree with him because the Supreme Court should be, in a sense, an objective arbiter of legality in our society. But, you know, Ruth Bader Ginsburg spends a lot of time in her 30-page, minority dissent talking about the history of labor laws in the U.S. And briefly, she says, to explain why the court's decision is wrong, I refer to the extreme imbalance once prevalent in our nation's workplaces. The end of the 19th century and beginning of the 20th century was a tumultuous era in the history of our nation's labor relations, and we had to do, essentially, a lot of legislation back then to protect the rights of our laborers. So that's why both the FAA, the Federal Arbitration Agreement, and the National Labor Relations Act were passed in the 1925 and 1935, respectively. Because, again, that's back in a time in American history when big business was monopolizing, everything at the end of the 1800s, start of the 1900s. And so the American public, especially after the Great Depression, had a reaction against this idea of big business and monopolies and corporate consolidated power. And therefore, the people, in theory, elected representatives who were consonant with the people's views and created laws to protect the rights of laborers. We haven't seen that so much after the Great Recession of 2008. We haven't so much seen that in the past 40 years in America, when corporations have been steadily increasing power. So I hope that kind of catches everyone up a little bit to Lewis versus Epic Systems Corporation, a Supreme Court case. There's another really important Supreme Court case coming up, Janus versus AFSCME, I believe, like a labor organization. And we'll definitely talk about that. It's coming up very soon, and that case deals with whether or not unions can compel people to pay money to join unions. And that's really important. If the Supreme Court says that unions can't do that, then unions will, in all effect, essentially be destroyed. And, of course, union membership in the U.S. has dropped precipitously over the past 40 years. So, folks, hope that was somewhat interesting. You are listening to Evidence of Design here at 100.9 FM WXIR in Rochester. Don't forget, you can always give us a call at 585-219-8889. Let's try that again. To 585-219-8889. And give us an email, evidenceofdesign101@gmail.com. But there's a lot of other things going on, of course, in the news, and we want to bring up one more point, one more evidence of the design of neoliberalism, and that is the proposed changes to the Health and Human Services Administration coming out of the Trump administration. Matt, do you want to lead us off on that discussion of those proposed changes?
Would you allow me to?
Please do.
Okay. So on June 6th, about a week and a half ago, Politico published an article stating that the Office of Management and Budget, or OMB, as I will refer to it from now on, will release its plans for executive branch reform by the end of the month. Chief among their known recommendations is a plan to consolidate the various welfare programs provided by the federal government under a single agency, the Health and Human Services Department, or HHS. The plan also reportedly suggests a name change to the HHS with something involving the term welfare. Now, it's interesting to note that when the HHS was formally established in 1953, it was called the Department of Health, Education, and Welfare, and was only later renamed in 1979 when many of its education-based responsibilities were transferred to the newly created Department of Education. Over the years, a number of HHS welfare programs have been removed from the agency and either ceded to other agencies or reestablished as specialized programs of their own, such as the Social Security program in 1995.
So you're saying that HHS is a department in the federal government that has undergone changes over time, and it seems pretty broad, health, education, and welfare at one point?
It was originally kind of like a catch-all department. From the research I did, it sort of grew out of a number of programs that were in development or had been around since like the start of the 20th century. And they were just later consolidated in the 50s. And then later on, people like President, I can't remember his name right now.
There's been a few presidents.
Potato farmer.
He's still alive. Jimmy Carter.
Yeah, President Jimmy Carter. Under him,
farmer.
Yeah.
You gotta go for something.
Those heuristics, man.
Bible study, brain cancer. Did he have brain cancer? I don't know. Probably not brain cancer.
We shouldn't speculate on that.
Yeah, I don't know.
But yeah, so under President Jimmy Carter, he really made a push to create the Department of Education, which I assume just so that, he could have a more specialized organization, or department rather, devoted to serving those kinds of needs.
Mm-hmm. And I believe that conservatives were always very much against the creation of the Department of Education, I believe, and they've always sort of been arguing over time to dismantle it.
I think it passed by just barely a 2/3 vote. It was 69 voted in favor.
Yeah. Even nowadays in elections, they some conservatives campaign on getting rid of the Department of Education, because in the Constitution, education is left to states' rights. But yeah, Matt, go on. So what else was in this plan, the Office of Management and Budget, that came out of the Trump administration?
Sure. So let's talk about why this push to move several of these programs back into the purview of the HHS. Well, at least one anonymous source associated with the OMB's plan was quoted as saying, quote, "You have low-income assistants in a bunch of different shops without one point of oversight and without a whole lot of communication. Why not have one federal agency responsible for execution?" I wasn't able to determine if there is a general lack of cohesion among the various welfare programs, and there is a lot, that inhibits their effectiveness, or if said programs would benefit from integration under a single department. But I would make the argument that the OMB under Trump isn't really concerned with streamlining the efficacy of welfare in America. Rather, they intend to dismantle it.
That's a statement. So
yeah. I'm making some claims.
You're claiming that the Trump administration isn't actually wanting to make the federal government more effective. They just want to dismantle it.
Yes, I will elaborate on this, but I guess I will say at this point that I think they want to sort of stigmatize further the concept of welfare to the point where it loses public support, and eventually they are able to either just cripple it to the point where it's ineffective or completely abolish it.
All right.
But before I elaborate on this claim...
Yeah, please, because I get what you're saying, but I definitely like to hear some solid,
evidence.
Evidence, yeah.
Yeah, because we're all about that on this show.
Evidence of design. Let's hear it.
I'd like to reiterate and emphasize that the OMB's report has not been published. It's due out by the end of the month. And consequently, there's a lot we don't know about it. At the same time, what we've already learned closely mirrors a number of recommendations suggested by the Heritage Foundation in June of last year.
The Heritage Foundation.
What's that?
Oh, boy. Oh, boy.
If you don't know, the Heritage Foundation is a conservative think tank that, Politico at least thinks, has greatly influenced Trump's policies since his inauguration. And there's plenty of evidence to suggest that. Actually, a executive order that Trump signed into effect last May, I believe, sort of followed suit with this Heritage report that I'm about to discuss.
It mirrors very closely.
Yes.
Yeah.
Thank you for saving my butt there.
Sure. Oh, also, I got a text from one of our listeners, and I think it's a fact check here that Jimmy Carter was a peanut farmer, not a potato farmer. So.
Well, you knew what I meant. So
we just got hard fact checked there, peanut farming. But yeah, so what did this Heritage report say?
So among the many recommendations that Heritage made were the idea of taking all the nutrition functions at the Department of Agriculture, which includes food stamps, nutrition education, and school and meal programs that serve some 30 million children each day, and transferring them under the HHS. The article goes on to mention that, quote, conservatives are likely to support moving food stamps over to HHS, in part because HHS has been out front on instituting first ever work requirements in the Medicaid program. Already, HHS has approved work requirements for Medicaid enrollees in 4 states, those 4 being Arkansas, Kentucky, Indiana, and New Hampshire.
And work requirements are something that conservatives like to bring up that says, look, if you want to receive social welfare, which is funded by taxpayer dollars, you need to prove and do and actually be searching for work in some
job.
fashion.
Yeah.
Not just searching for, but even sometimes actually need to be holding a job or holding some sort of work while you're on these programs.
Right.
And I hope, Matt, you'll get into talking about how if you have some income, you might not be eligible for the programs that you need to actually get yourself truly on your feet to get out of your conditions where you need those programs to begin with.
Well, Jason, it's almost like you've read my notes. So
No, that's just I hear that all the time with just work requirements, and it requires so much more nuance than just saying, because obviously, if you're on welfare programs or social safety net programs, you should probably trying to look for work because that's kind of how our society is structured, But the conversation goes so much deeper than that in terms of how it actually affects the lives of people who are on these programs and looking for work, and it warrants a greater discussion. So that's all I'm trying to say. Yeah.
Now, before we go any further, I do want to make a quick distinction between Medicare and Medicaid, because the two seem to be wildly conflated and not necessarily always understood in common parlance.
And you just said that Medicaid has work requirements.
That's right.
Okay.
So Medicare is a program that provides health coverage if you are 65 and older or have a severe disability, no matter your income. Medicaid is a program that provides health coverage if you have a very low income. Sounds pretty simple, right? But there's one difference I've yet to mention, which is that Medicare is a strictly federal program, while Medicaid is both a federal and a state program. Now, this is important understanding some of the nuance to the work requirements HHS recently approved for Medicaid, because while HHS has approved these requirements in 4 states already, another 9 states have applied, but they have yet to be given the go-ahead. And those 9 states are Kansas, Maine, Ohio, North Carolina, Arizona, Utah, Mississippi, Wisconsin, and Michigan.
So not New York. New York does not have work requirements for
We
Medicaid.
are good.
Okay. Do you know what those work requirements are? Like, do you know what is the work requirement?
I was only able to find work requirements listed for the state of Michigan, and I'll go into those now. Actually,
yeah, I'd be curious. Like, what are they? What are the actual work requirements?
So, an article published by the Detroit Free Press just 2 days ago tackled this topic pretty in-depthly, and a quote from that says that Michigan's legislature did not pass a bill that requires all Medicaid recipients to work. It passed a bill that asked the federal government to let it, as of January 1st, 2020, require able-bodied adult Medicaid recipients under the Healthy Michigan Plan to work, look for work, volunteer, or be in training or in school for 80 hours each month, unless they are otherwise exempt or risk losing their benefits. There is no guarantee the Federal Centers for Medicare and Medicare Services, CMS, which is a part of HHS, will grant the permission to allow this, though President Donald Trump's administration earlier this year signaled it would be more open to considering work requirements for certain Medicaid enrollees.
So the Michigan legislature did not pass this bill?
The Michigan legislature did pass the bill,
Okay.
but they still require the permission, basically, by the HHS in order to implement it.
Okay.
That seems to be the relationship between
yeah.
So, like, from what I understand, it seems that states have some degree of latitude in determining what these actual work requirements might be.
Mm-hmm.
They just need to get, because Medicaid is a state and federal program, they need to get permission from the HHS in order to implement any sort of work requirements to begin with.
Mm-hmm. Okay. Yeah. Usually you hear, like, if you don't make it federal, you can do like something called block grants. You kind of pooling money together to allow states to implement whatever, social safety net programs they want. You heard of this a lot with Medicaid, Medicare, but also the Affordable Care Act. Mm-hmm. Or typically the conservative argument is leave it up to the states to figure out where to spend their money. But of course, at all times, I think, I don't know, maybe this is incorrect. I think most states now are in budget crises because we've lived through 40 plus years of just tax cuts. And so the governments don't have money to do the things they need to do to support their people. And so it's a really simple argument to say, yeah, just make the federal government smaller. You'll save federal government money, put it all in the states. But the states don't have money either. And so, I'm not sure that's a solution either. But
yeah.
So what else is in this whole piece here. We're talking on Evidence of Design here, 100.9 FM WXIR, about two real examples that are just happening in the past week or so, and this is going on right now with the proposed changes coming out of the Trump administration to kind of reorganize social safety net programs, specifically in the Health and Human Services Department. What else is kind of in that story, Matt?
Sure. So some people who we have not convinced yet might be thinking, well, what's your point, Matt? What's your point, Jason? Where's the evidence?
Yeah.
Where's the evidence? I mean, what's wrong with making a few Medicaid recipients work for their coverage? I mean, if they're able to, doesn't seem like anything wrong with that.
Mm-hmm.
My response to that, thank you for asking, would be that most Medicaid recipients either already work or would be exempt from working under Michigan's proposed requirements. And Michigan's proposed requirements seem to be sort of a standard, if you will, like sort of the popular idea of what this of what these might look like, basically.
Interesting.
In a study conducted by the nonpartisan Kaiser Family Foundation, it was reported that, quote, nationally, more than 6 in 10 non-elderly adults in Medicaid who do not receive federal disability or Medicare coverage are already working full-time, 43%, or part-time, 19%. Nearly a third of non-elderly adults in Medicaid who don't receive disability payments report that they are either in fair or poor health or are not working due to illness or disability. 15% are not working because they are caregiving, 11%, or in school, 6%. All are reasons that could exempt them from work requirements. That leaves just 6% who would have to get a job or participate in training or volunteer activities to meet the new rules being pursued in some states.
So this report by the Kaiser Family Foundation says if you actually look at all the different types of requirements going on here and the different types of eligibility, you're really only getting to 6% of all Medicaid recipients who would be eligible for these new work requirement stipulations. Right.
So Medicaid, as I went over briefly before, is for primarily low-income people.
Mm-hmm.
There are people who are dually eligible for both Medicaid and Medicare. But if you look, the Kaiser Family Foundation study found that if you look at Medicaid recipients, most of them are either working already or would be exempt under the stipulations that these work requirements are already putting in place.
Yeah. And that's what you have. I think it's called the working poor, where you have people who are working and they're still in poverty,
right,
which breaks the entire purpose of like Americanism, right? Like the American dream and hard work and
the whole idea of a meritocracy.
A meritocracy, yeah.
If you just work hard and do your duty, everything will work out.
Right. And I think a huge reason for that, Matt, is we've talked on the show before about how wages in the U.S. have not really increased over the past 40 years. Nominally they have. People are making more money in their paycheck than they were 40 years ago, but when you adjust it for inflation and the cost of living, the actual purchasing power of your dollars essentially hasn't risen over the past 40 years, which coincidentally aligns with the sort of the instantiation of neoliberal policies, such as making big business more powerful. So I think what you have happened here is we're still using the same rhetoric: get a job, get a job, get a job, get work, get work, get work. But work doesn't carry the same power that it did. You can bust your butt, as I think we'll hear our president say pretty soon, and you can bust your butt, and you're still not getting anywhere in life.
Well, I am so happy that you brought that up, Jason, because there's nobody I know that can talk about neoliberalism like you can. I almost made it through that sentence without flubbing it. Anyway.
Yeah, so, I mean, this is really frustrating to me because it's such a complicated topic. Can we actually hear for Donald Trump to hear...
Oh, not yet, Jason. I'll bring it up. Don't worry.
All right. Let's hear then. What else?
Sorry, I'm just trying to find my place.
Of course.
So one thing I want to bring up, this sounds like a lot of work, a lot of tedium just to squeeze some money out of the 6% of people on Medicaid who this would affect. And I think we might gain a little more insight, excuse me, if we look at another welfare program known as the Temporary Assistance for Needy Families, or TANF. TANF was signed into law by Bill Clinton in 1996. It replaced another program known as Aid to Families with Dependent Children, or AFDC. In 2016, The Atlantic wrote a piece covering TANF and how it differed from AFDC. They wrote one of those main differences was that it imposed work requirements and limited how long recipients could receive benefits. So, like we're seeing now with Medicaid in some states, this TANF imposed work requirements and also limited how long families, individuals, could be on it. This change had drastic repercussions, as the same article continues, quote, as of 2012, according to the most reliable government data available on the subject, roughly 3 million American children spend at least 3 months in a calendar year living on virtually no money. According to the most recent data available in 2014, TANF rolls are now down to about 850,000 adults with their 2.5 million children, a whopping decline of 75% from 1996. TANF was meant to replace AFDC. What it really did, in reality, was essentially kill the U.S. cash welfare system. End quote. Now, that article goes into numerous details about why exactly TANF has been such a dismal replacement for AFDC. And we don't have time to look at them all. However, I think it's important to say, for the sake of accuracy and my own integrity, that the work requirements in TANF are not the sole cause for its ineffectiveness. There's a lot of research into how actually states have been able to tap into those funds and abuse basically TANF for their own purposes.
Can I just say, this is coming from Bill Clinton.
Yes.
It's almost like both Republicans and Democrats in some ways are complicit in this political economic shift that we're talking about.
How very perceptive of you, Jason.
It's also worth noting, I think, that TANF, the Temporary Assistance for Needy Families program you're talking about, Matt, I think that constitutes like 5 to 6% of the Health and Human Services budget. So it's really a nominal, it's a small part of the budget of Health and Human Services. It's worth pointing out, where people often say like social safety net programs are so expensive. I mean, sure, compared to the price of milk or something, but
yeah,
it's all relative. So it's really quite a small percent of the budget.
And this all ties into, I guess, my main point, which is what these work requirements really reflect is a sentiment encouraged by conservatives since at least the 1980s, which is the idea that the welfare system is ripe for abuse and that a significant number of recipients are already taking advantage of it. Now, I don't think I need to offer up any evidence to support the claim there is a strong negative stigma surrounding the term welfare in modern America.
Why not?
Well, I'm going to anyway.
Why? Come on,
Well, let's see. I could point you to any number of stories about mothers refusing to apply for TANF, even when they needed it, because they didn't want to be thought of as, quote, leeches on the government, end quote. Yeah. Or academic studies that research the use of the derogatory term welfare queen by both politicians and the media, and the role it played in undermining public support for the AFDC.
Which is also tied heavily into racism, right?
Exactly,
yes. Economics. Yeah.
The actually, I could go into that a bit. The welfare queen term has strong associations with black women because of its use over the years, and the negative stereotype that women need to be controlled sexually, and that black people are lazy.
Yep. Yeah, it's all tied in, the economic just sort of control and the racism and the misogyny. It's all part of the same system here.
But luckily, Jason, we don't need to look any further than a speech given by our current president for a succinct contemporary perspective on welfare.
I am so excited because, if anything, Donald Trump is known for succinct, intellectual...
Mr. Trump, will you please elucidate on your views?
Let's hear.
But welfare reform, I see it, and I've talked to people. I know people, they work 3 jobs, and they live next to somebody who doesn't work at all. And the person who's not working at all and has no intention of working at all is making more money and doing better than the person that's working his and her ass off. And it's not going to happen. Not going to happen.
So the person who is working 3 jobs is worse off than the neighbor who is on welfare.
I'm just getting a call from my conscience. I don't believe that's true.
Yeah, and Donald Trump said that in a speech in 2017, end of last year, I believe, in a campaign-style rally, because he's permanently campaigning for office for life. But
like Putin.
and President Xi Jinping and leader Kim Jong-un, but I digress.
These are just comparisons we like to throw out.
Yeah. But I mean, that is obscenity, right? That is absolutely ridiculous. And what really saddens me though, Matt, and I hope you talk about YouTube comments here, what really saddens me is like people cheer, you know? Like,
They love it.
I don't spend a lot of my energy debating Donald Trump because he's an obscenity and like not worth debating intellectually. At some point, like I'm not saying you discount everything he says and write off all the people who believe in his policies, but like at some point it is not worth the time of your existence to like debate Trump tweets, right? And to debate every obscene thing he says. I'm more interested in the consciousness and the psyche of the people applauding Donald Trump.
Sure.
Like what is going on there? And that's what I'm interested. So like, do you want to talk about YouTube comments and like even to that video, what people were saying?
Yeah. Well, they like it.
What
There
it
you
was
go.
they and they like what?
So, interestingly, I don't actually know what the political leanings of the person who posted that video are.
Sure.
I think you could interpret it just from the title they gave it that they don't support Donald Trump's take on welfare.
Yeah.
But the responses are overwhelmingly positive. Overwhelmingly positive for Trump's views. They are overwhelmingly negative for anybody who identifies as a human being. But let's just look at some of the things that people wrote. Here's one. Trump says what people who work hard to make their living have been saying for decades. That's one of the more tame.
Yeah. And we have to keep these PG
examples.
because we're on radio. We can't even read.
One of my favorites was down with welfare. It should only be for the qualified, which doesn't really seem to make sense, except I think this is emblematic of of the stigma that conservatives had created around welfare, where people don't even think of the system itself as welfare. Mm-hmm. They rather think of the abuse of the system as welfare.
Mm-hmm. That's a very interesting point. People think of the abuse of the system, and that abuse of the system is often tied with, again, racist, misogynistic, class-based points of view.
Yeah.
Not abuse as in, like, someone is stealing a bag, like, pocketing a bag of money. Like, you know, I mean, that's pretty obscene. But, I mean, we've talked a lot on the show. We've had 3 episodes on Facebook and the ongoing sort of what am I trying to say here, Matt?
I don't know.
Controversy. I was going for your British controversy and trying to combine it with the American controversy.
I wouldn't recommend that for myself.
So there's ongoing controversy with Facebook and what constitutes essentially free speech online. And, you know, YouTube comments are not the best place to go to make yourself feel happy about the world. I think we've talked about this before, actually, on our 5th episode of the show. But I'm really curious about what is that psyche that compels people to vilify recipients of social safety net programs. And I'm not sure I understand it. And I'm not sure. Well, I'm just a little worried, like, combine that, right? Combine this culture in America that tends to be really scared and vilifies social safety nets with these other more hidden mechanisms like the Supreme Court case to make it illegal for workers, right? So now we're talking about people who are doing what they're supposed to do, so to speak, who are working in a private sector non-union job and who are getting ripped off by their companies such that they have to go to court against them with other employees. And now no longer are they able to do that because they have to arbitrate it individually with their company. And Matt, can you imagine if you were like, I'm getting ripped off by my company, I'm mad at them. Well, now I have to abide by this individual arbitration agreement and go meet one-on-one with my company. Do you think they're going to keep you on as an employee?
Apparently, I don't have to imagine it anymore.
You don't have to imagine it because you, of course they're probably going to fire you, right? Because now you're a trouble employee who just wants perhaps what you've worked for, rightfully. And so it's like you can't win on either side, right? You either get a job and do what you're supposed to do, so to speak, and you're still ripped off by the companies, or you're stuck in this rock and a hard place and like trying to survive on social safety net programs that have perhaps work requirements that make it impossible for you. So even if you get a job, let's say, even if you get a job, now you're no longer now you're no longer on those social safety net programs, but you're making $8 an hour because that's what like the minimum wage is, because wages haven't risen. So there's nothing you can do. So this system has created this phenomenal underclass of people who have no choice.
Yeah.
And no wonder Donald Trump can get on stage and rail against the deep state and the system is broken and all of that, because the system's absolutely broken.
Right. Well, these are just scapegoats.
Yeah.
When Donald Trump is like railing on against, illegal immigration, he's doing that to redirect a very real anger and a sort of knowledge that I think the American people have that they're being ripped off.
Mm-hmm.
But the thing is that Donald Trump and his ilk are the ones that are responsible for that, not immigrants or anybody else.
Absolutely. We mentioned this a little bit, but do you, Matt, in your own words, have where's the connection to neoliberalism then in Trump's proposed changes to the HHS and social safety net programs? Is there a connection at all?
Well, I have a lovely little paragraph prepared for you, Jason.
I'm curious. Like, where's this connection here? Because I know I can just keep saying the word, but let's hear the evidence of the design.
Is that our catchphrase now?
That is.
Here we go. Why do conservatives seem to hate welfare? The answer, I argue, is neoliberalism. Neoliberalism is a term that you and I have thrown around on this show a dozen or so times before. We've even dedicated 2 whole episodes to defining it. But to give a quick summation, well, we already did that.
It's a set of economic practices that
began to gain traction during the 1970s before seeing widespread adoption under Reagan in the 80s. At its core, neoliberalism prioritizes the deregulation of the private sector, the shrinking of the federal government's involvement in social welfare, and the proliferation of big business. The problem with neoliberalism is that it has concentrated an obscene amount of wealth in the hands of a very small number of people. Evidence shows that the economic opportunities of our generation are nothing like that of our parents. While productivity and the cost of living in America has steadily increased in the past few decades, wages have remained at roughly the same spot, as you said earlier.
Yeah.
Perhaps most famously, the 2008 financial crisis was a direct result of neoliberal policies going unchecked for decades.
Mm-hmm.
In the following years, Jason and I believe that America has experienced a kind of awakening. Many Americans understand that opportunities in America are not as prevalent as they used to be. Many Americans feel they're being cheated somehow. Trump has capitalized on these feelings of resentment by directing them at easy targets. He's made scapegoats of illegal immigrants, claiming they're responsible for stealing jobs from hardworking Americans and living off welfare checks that they don't need. The reality, of course, is that it's not immigrants, illegal or otherwise, that are responsible for the worsening economic conditions in America. Rather, it's the growing influence of people like Trump in our political sphere. The Republican Party is composed of and supported by the richest people in our nation, the people who have most benefited off these policies, while the rest of us have struggled to get by with less and less. They have a vested interest in redirecting this social unrest, so that their own sins continue to go undiscovered by the many, so that they may continue to surreptitiously accrue more and more.
And the Democrats, too, as well, because we mentioned Bill Clinton and the Democrats, by and large, have supported very many of these neoliberal policies. Hillary Clinton, for example, was...
Many Democrats align almost perfectly with modern Republican economic policies.
Right, absolutely. While they may not cut taxes to, 15%, they may only keep them at 35% and all the rest of it. They speak nominally about deregulation and regulation and taxing millionaires, but when they get into office, either because it's politically impossible or they just don't really try. But I think we're seeing a little bit of change of that in terms of people having an awakening. Bernie Sanders and Donald Trump may have, were the tip of the icebergs of spearheading this awakening, and would have been interesting to see, if it was Bernie versus Trump. But we are definitely on to a different awakening in society. So, folks, I hope you enjoyed those 2 different real-life examples of neoliberalism, the Lewis versus Epic Systems Corporation Supreme Court decision, and the Trump administration's proposed changes to the Health and Human Services Administration. We'll have to keep our eyes on what the changes are. I think the report comes out this month, so we'll be back to you to talk about that. But this was our 13th episode, I believe, of Evidence of Design. My name is Jason Taylor. Thank you so much for listening. We are also joined today by my good friend, Matt Treadwell.
Goodbye.
I hope you all have a great, great weekend. It's a nice day out today. Be well, be safe, and folks, bye-bye.